Okay. So let's go on the record on cause number DC 1918220, Zabark versus Gonzalez. Counsel, make your appearances.
David Welch on behalf of the plaintiff, and Mr. Zubarik's also on.
Caitlin Coker on behalf of Defendants, the First Amended Phillips Family Trust, Eric Sorensen, Jamie Sorensen, Lindsay Smelser, and David Smelser.
Kelly Milligan for defendant Ronnie Henderson.
Greg Fell for defendants Francisco and Marianne Gonzalez.
Brent Bisey for third-party defendant, the Valley View Park Estates HOA.
Is that everyone? All right, let's go ahead and start. There's two motions. Which one do you want to do first? The motion to reinstate or the motion to quash?
Either or is fine, Judge. David Welch, the reinstate, what you're going to hear is that the vote did pass. So I'm assuming you're going to deny that motion, so we can start there if you want.
Judge, that is correct. The amendment did pass about a week and a half ago on July the 1st. The vote passed, and it has already been filed with the county records as to the passing of the instrument and the amendment to the declarations. As it relates to the motion to quash that's also set, the HOA has filed a motion for protective order that covers this motion to quash as well as another motion to quash. We've been working with the clerk's office to try to get that set today, since the motion for protective order covers all of these issues, and that the motion to quash is for depositions of non-parties. And I am also counsel for those non-parties that are included in that motion for protective order. And so we can either take that up today, or we can reset the motion for protection. Because as I understand it, plaintiff's motion to compel is actually the response to our motion for protection.
Yeah, Judge, there's been three kind of motions together. There was a quash. I filed a motion to compel and for sanctions that's supposed to be set today, and then the protection, and they all kind of deal with the same issue, Judge. So I think if we take one up, we can just take them all up.
Is anyone opposed to that? Speak now. Okay. And guys, go ahead and unmute if you're here on the hearing, just so we don't have to go back to muting and unmuting. Okay, let's go ahead and go forward with the motion to quash then.
Judge, so as it relates to the motion to quash that was filed, there's technically two motions to quash that were, both of which have now been subsumed by the motion for protection that was filed on June the 21st. And in that motion for protection, the HOA, as well as non-parties, Ida Caruso, Art Bolin, Patrick McNanaman, Councilman Terry Lynn, Patricia Link, Peggy Sterling, Cynthia Goodsell, and Judd Austin are all asking the court for protection from plaintiffs' subpoenas for oral deposition. These subpoenas were served on all of these non-parties, and so far, the plaintiff has actually sought to depose 17 individuals in this case. Of those 17, 13 of which are non-parties. During the course of the depositions that have already occurred so far, deposition transcripts have been attached to, they were not attached to this motion because they're not available at the time. However, we have subsequently filed other documents with the court, which has the deposition transcripts, which supports our relief here, which I can refer to the court to in a moment if needed. However, the issue that's before the court is whether or not these depositions of non-parties should be permitted. The non-parties, as well as the HOA, joined together to argue that protection is needed because the depositions that are being sought are outside the scope of discovery pursuant to Rule 192.3 as well as 192.4, which that is the limitation on the scope of discovery for being unreasonably cumulative, duplicative, and obtainable from another source that is more convenient, less burdensome, less expensive, or if the burden or expense is outweighed to the benefit or importance of the discovery that has been sought. In these depositions, Judge, the vast majority of the questions, well, up until this point, have been regarding the nature of the vote to the amendment that just recently passed. They related to improper hypotheticals as to why people voted a certain way, whether or not they would vote differently, who is and is not a member. However, the key issue to this litigation, if we all remember after all of the various times we've been here, is relating to issues as to a utility easement, whether that easement was violated and whether or not there are other issues involving other easements. None of these issues before the court have anything to do with member voting, membership, or how people should or should not vote, or who said what and when. All that matters, Judge, is issues related to a utility easement and fences. So all of these depositions have been sought. These are for individuals who are not either, they do not live along the perimeter of the neighborhood, who are trying to build fences themselves, people who have really no vested interest in the outcome of this litigation. The only issues that are before the court do not pertain to these individuals. Some of these people, we believe, are being asked to sit for deposition because they used to sit on the board of the board for the HOA, or members of the litigation committee for the HOA, which those issues can be taken up through a corporate rep depot, not by bringing in 13 individuals who cannot speak to the merits of this case or provide new information that would assist this court in adjudicating these issues or providing anything of substance.
I get it. Mr. Welch, you're the one asking for the depositions, right?
Yes, Judge.
So I don't know the best way to do this. Do we want to go through them, Mr. Welch, one at a time, and why you feel you need each one, or how do you feel like the best way to do this is?
I think I can do it kind of globally. I'll start there, Judge. One, that is not what this case is about anymore, and that's because Counsel Bisey himself asked for this case to be more than just an easement issue. If you'll recall, when you were out of town, Judge, you granted a consolidation that the defendants filed on an emergency basis, adding all of the fiduciary duty and fraud claims and receiver requests to this lawsuit. So everything counsel just told you is not true. That's not what this case is about any longer at the defendant's own request. So I don't know how they're going to say that these depositions are irrelevant to those issues. But I think we need to take a step back, Judge, and look at kind of the truth is in the details. If you'll look at what was actually filed originally, and this timeline is laid out in my June 21 motion to compel, Judge. I can put it on the screen for you, or
yeah, why don't you do that?
All right, let me do that. All right, can you see that, Judge? Let me make it bigger.
Yes.
So just for way of background, this motion primarily deals with one of the depots, a gentleman named Terry Lynn, who we've kind of talked about a little bit, but it lays generally how we wound up here. So back in May, I began looking for depositions, and I sent a request for, I don't remember how many it was, 17 or however many people. No one responds about Terry Lynn, and they start responding about, we'll give you depots for our people and things like that. Mr. Kramer writes, I said, the HOA has claims against my client, please let me know. They don't give me any dates. So this is all that they ever write. Mr. Kramer, who's Mr. Bisey's boss. So on May 19, Mr. Bisey writes, we'll accept service for the litigation committee people, these three people. Now, back in May, they're saying they'll accept service and the depot can go forward. Now here in July, they're saying it's irrelevant. The narrative's going to switch very soon, Judge, and that's when they start losing and the recount and things happen. They don't give any dates, especially with Terry Lynn, nothing happens. 25, I write again asking for dates. I don't get anything. So then finally, I unilaterally notice depositions for dates, and I set Mr. Lynn, and that goes out on May 28, 2021. That's an important date because we all know you have 3 days to quash a deposition for it to be automatically quashed without hearing. On June 3, there's a motion to quash for these 3 folks. The one that they say back in May 19th that they'll give me dates and that they represent and they'll accept service. So I don't know what's going on, but that's all that's quashed on that date. On June 8th, Mr. Lynn is served. I have to jump through the hoop of getting him served. June 11, counsel writes me and says, we were recently retained for Mr. Lynn. Let me know if you'll reset his date. I said, let me know. I'll agree, but you got to give me a firm reset date. Well, I don't get a reset date. What I get is Valley View, second motion to quash. Now, Valley View was noticed this date on May 28th. This is 3 weeks later that they're now moving to quash it. It's late, untimely, and it only quashes again Goodsell, Sterling, and Patricia Link. So 3 more people, never Mr. Lynn. On June 18th, I send the deposition link. Then, all of a sudden, now that the depots are set, going forward, it's too late to quash, then we get this motion for protection. So, I don't really know what's going on at that point, but here we go. And Mr. Lynn is not in that motion. So June 20th, for the first time, all of a sudden Counsel Bisey pipes up and says, this depot's not going forward tomorrow. What do you mean? So then myself, the court reporter, and Counsel Fell, who represents Francisco Gonzalez, show up. There's a certificate of non-appearance. So that's what's really happened here, Judge. They're coming in and saying we need protection for however irrelevant it is. That's not the case anymore because it's all consolidated. Second of all, it's all untimely. This is all tactics. They waited a month and a half to file the motion for protection, saying this is an emergency, we need it, it's out of control. That's not true, Judge. The depositions are relevant. They're all former board members, people with fences, people that had decision-making on the fences, or they're people that know what's going on with this litigation committee. The HOA has affirmative claims. I'm entitled to get the deposition of these people for their seeking attorney's fees. No one will ever tell me how much the attorney's fees are. I've asked every person, no one knows, or Mr. Bisey objects. I don't know if they're waiving that or they're not going to seek that at trial. So the timeline does not make sense. It does not add up. I've asked, at least for sanctions against Mr. Lynn, for never quashing his depot ever, especially not timely. And I need to get these dates for these depositions. We need to move forward. This case needs to go to trial and be done, Judge. So that's kind of the response. And
I definitely agree to the last point there.
Agreed, Judge.
For sure.
In a very brief response.
So guys, I don't know how I rule on all 17 of these requests just globally. I don't know what each of the reasons for each of the individual depositions are, and
So, Judge, as we don't represent, we're not trying to seek protection for all 17. The 17 include defendants as well as non-parties alike. So far, 1, 2, 3, 4, I believe 7 of the 17 have gone forward already because they were either defendants themselves, which we were not going to stand in the way in, or they were non-parties of which that we no longer represent. The motions that we filed were within the motion for protection, Judge, was filed within about a week of us becoming counsel for these non-parties. Opposing counsel really brushed over the difference there in terms of when he initially noticed it, these people were not our clients. I cannot speak on behalf of people I do not represent. Counsel knows that. So it is very disingenuous to make that argument that there's just this hesitation and wait. Furthermore, Judge, in the reason why, when it comes to Councilman Lynn, why protection is of the utmost importance in that particular situation is the day of the deposition for Councilman Lynn, plaintiff produced over a dozen pages regarding Councilman Lynn's political gossip and drama in D Magazine. It is a foregone conclusion, Judge, that plaintiff is seeking to basically harass, intimidate, annoy, and make a spectacle of this deposition, as have been most of the depositions thus far. There's been very inappropriate accusations. There have been insults and slants, calling of names. Myself have been victimized by that as well. And all of this is included in the declarations, or I'm sorry, in the sworn declarations that have been attached to the motion for protection. As it relates to Patricia Link, she doesn't even live in this neighborhood anymore. And as it relates to Peggy Sterling, who is another individual, she's not in a position with her personal health to be able to competently sit for a deposition. These are things that we've all provided.
So let's go to, there's a lot of people's names. So there's 10 that are still, we're fighting over. Is that right? You said there were 17 and 7 have been taken. So there's still 10 that we're fighting over?
There are 8 that I represent, Judge.
And then what about the other 2?
I am not aware of that situation for the other 2.
Mr. Welch, so let's go through the 8. Mr. Boyce, who's the first one? Ms. Lynn, she's a city council member.
Oh, sure. We can start with Mr. Lynn. He's a council member for the City of Farmers Branch. His protection is absolutely paramount and important because he is a political figure. This is definitely motivated for political means. The plaintiff formerly ran against Mr. Lynn for that council position and lost. His politics has nothing to do with this case, Judge. And the fact that this was being produced in discovery, it's very clear what this deposition is going to be used for. He doesn't even live along the perimeter, have a fence at issue.
Does he live in the, well, why do you need Mr. Lynn's deposition, Mr. Welch? Is it because he's a city council member or because of some personal activity he had in this particular situation?
Yes, Judge. He serves on the litigation committee. He's actually the main one that's kind of guiding how this case is being handled by the HOA. Second of all,
he's not on the litigation committee, Judge.
I don't know who said that or what that was, Judge.
I
attended the. I'm sorry.
This is a little bit difficult. Mr. Boyce says he's not on the litigation committee, and you said that he is on the litigation committee.
I've heard he is on the litigation committee, Judge. Second of all, March.
Your Honor, I have an affidavit that's signed that says exactly who is. It's not. It's attached to our previous multiple times our emergency motion from just the other week, where Ida Caruso provides all the information for the litigation committee. The members are herself, Art Bolin, and Patrick McNanaman. Those are the 3 people on the committee.
Judge, I've heard he's been on it previous. I don't know, but I've heard he's been on it. And second of all, the March 23rd vote, Mr. Lynn is the main one talking. I could play the video for you. He's the one talking about my client, about who's being sued, what's going on. He has knowledge on what's happening here, Judge.
Is that true? Is he at the meeting?
Yes, Judge, he was there at the meeting. He is among the members of the HOA. He did, I guess, kind of host the meeting during the votes because he's involved in local government. He is taking a bit of a leadership role, I suppose, but he is not a member of the committee. He was at one time, but he has not been for a considerable period of time during this case. He used to be the president of the HOA for, I'd say, 7 or 11 years, but this has also been a long time ago. He does not live along the perimeter of the neighborhood. He has, other than just moving through this process with the membership, because plaintiffs made such an issue with the board being a part of it, the members have been the ones that have had to take it up. So it just seems that whoever wants to take this issue up, plaintiff is going to have an issue with. And then the fact that we are producing documents regarding his political campaign, that's a serious issue especially given we've already demonstrated that the plaintiff has breached the confidentiality of member votes and that protected information.
Mr. Boyce, let me just say this. So I agree with you. Anything involved in his role as a city council member, anything involved in his political campaign, anything like that would not be discoverable. I don't see any relevance to this case. But if he was on the litigation committee and he was actively involved in the meeting and how this it doesn't create, if I'm a judge, I have absolute immunity pretty much to any type of lawsuit against me as long as I'm doing the work of a judge. But if I go out and I, get into a car accident, I don't have immunity for that. If I go and join, if I'm on the board of an organization and I steal money, I don't have immunity for that. And so he is immune. I agree. There shouldn't be any discovery based on his role as a council member, but he's kind of stepped out of that and taken a role in this organization in a different way. And so what I'm going to do is I'm going to allow a 1-hour deposition of Mr. Lynn. I want to make it clear that anything involving his role as a council member or his political campaign is not going to be discoverable, but anything that he did as a member of the litigation committee or involved in any of the types of meetings and the homeowners association. And then I would encourage you guys, because I could imagine this being difficult, that do this over Zoom, and then if you need me to intervene at any point during the deposition, because there's a question about what if the questions are appropriate, I'm glad to do that. It's going to be a little difficult because we're about to get into a wave of trials. But anyway, so that's the deal with Mr. Lynn. What's the next one?
Judge, for the next three are all current members of the litigation committee. We would think that in the interest of judicial economy and also the expense that has been incurred here, that there be a single individual that we can designate as the corporate representative for the committee, so that way we're not having to do 3 depositions.
That makes sense, Mr. Welch.
Normally I would say that's fine, Judge, but they're all going to have individual knowledge. I'm happy to limit the time, and then they can tell me who the corporate rep is, but I would like to take all 3.
Judge, I don't believe that the plaintiff has demonstrated the burden. He's not met his burden as to being able to get all 3 of these depositions. A lot of this information he can get from the records of the HOA. If he wants to know why certain decisions were made, he doesn't need all 3. He can just get one to speak on behalf of the whole group.
The burden's not on me, Judge.
At this point, I'm going to allow a corporate representative. This may change if it turns out there's something that comes up, but at this point, I'm going to allow a 2-hour deposition of a corporate representative of the litigation committee. What else do we have?
The next one would be Patricia Link, Judge. She was a former board member. She no longer lives in this neighborhood. She now lives in Carrollton, not even Farmers Branch. She's left, sold her home, has no property interest, has nothing to do with this anymore.
Why her in particular, Mr. Welch?
She had some knowledge about the fences and the ACC, Judge. That'd be the same for Ms. Sterling and Ms. Goodsell. I actually talked to Ms. Goodsell on the phone when I first subpoenaed her, and Ms. Goodsell was willing and happy to set it for a depot. I actually even rescheduled it, so I'm not sure why hers ended up getting quashed, because that was at her convenience. We reset that date.
Judge, if he's looking,
those were all people that were related to the ACC, which was the architectural committee that ultimately wound up saying you could build the fences, which you've ruled previously that was in violation of the old declaration in place at the time.
Judge, though, if plaintiff was looking for a deposition of the board, then certainly, again, this is a situation where a corporate representative is the most appropriate means of getting that information, aside from the fact that the minutes of the meetings and all that information is available online through the member portals. none of these individuals, if I remember, or these individuals were not a part of the ACC during the time period. Those three individuals were all members of the board. When it comes to Ms. Sterling also, she is not fit to sit for a deposition. Yes, she's not fit to sit for a deposition. Ms. Link does not live in the neighborhood, and Ms. Goodsell has not been on the board since 2019. All three of them ended their term on the board in 2019. So if plaintiff is looking for someone to speak on behalf of the board, then we'd be happy to try to find a corporate rep similar to the litigation committee. There's just not a justifiable means to have depositions of former board members.
Okay, so there's a difference. Who was a member of the ACC between Link, Sterling, and Goodsell? Who was on the ACC?
Judge, Goodsell is what I understand. Given the Miss Sterling's health, I'm fine holding off on her. The main one I want of those three judges, Miss Goodsell. So I would ask at least I could take that one.
All right, I'm going to allow a 1 hour deposition of Miss Goodsell. And I think there's one left. Who else is left?
Patricia Link. Oh, and Judd Austin.
Who's Judd Austin?
Judd Austin is the former HOA attorney. I think it's pretty obvious as to why this individual should not be deposed, as this is going to horribly invade attorney-client privilege communications.
Mr. Judd Austin sent a letter advising the board that they are not allowed to build these fences, and then was fired because of it. So we're looking.
That is untrue, Judge. The document can speak for itself, but the motivations for whether or not he was terminated or if he left on his own free will, in terms of his representation, that's just what counsel's saying. He has no idea.
It's 100% true, Judge, and that's why we need the depot.
How do you get around the attorney-client issues?
Judge, I don't believe that there's a way around that issue.
My client's a member of the HOA, Judge, and as a member, I think he's entitled to learn what's going on. We could do the depot under some kind of seal or something, but he certainly gets to learn. When there was that'd be an anticipation of litigation objection, and there was no litigation anticipated at that time. My client as a member is entitled to know what's going on. This goes to the heart of the receiver and the fraud issues, Judge.
Your Honor, leading up to this point, but before the lawsuit was ever filed, the plaintiff had made it very clear he has anticipation to sue. He had his current attorney send a letter to the HOA board. In terms of anticipation of litigation, it was very much anticipated. And even though that Mr. Zubark is a member of the HOA, he cannot unilaterally just waive the privilege for the other 86 members of the HOA. The document that Mr. Welsh is referring to, it speaks for itself. It's been produced in discovery. That there's no new information that can be acquired from Mr. Austin that would speak to the contents of that letter or the decision making at that time. He was also not the attorney whenever these new issues that were consolidated into the current case became ripe for litigation. So there's, again, no need for Mr. Austin to sit for a deposition.
Is there any allegation that Mr. Austin did anything outside of his role that's relevant to this case as the attorney for the board?
No, Judge.
There's no allegations Mr. Austin did anything untoward. With the allegations actually that Mr. Austin.
I just mean outside of his scope as the attorney for the board. At this point, I'm going to go ahead and quash that one. I may revisit that in the future if additional evidence comes forward. And you will be allowed, Mr. Welch, to ask the members of the board why he was terminated, and if they, I may allow you to ask some limited questions of Mr. Austin. If, let's say, the board says we terminated him for malfeasance, and he says, no, you terminated me because of the position I took, then I may allow you to go into that, but only on a very limited basis. But at this point, let's see what the board says. Or has the board testified about that?
No, council's actually refused to let anyone testify on their personal knowledge about any question to the board. So hopefully this now is going to get me some of those answers that I've been asking for, Judge.
All right, get me an order on this, Mr. Boyce, and make sure that it says that this hearing was heard on July 12th. Make sure you share it with Mr. Welch, and make sure you email it to both my court coordinator and you e-file it. Anything else we need to chat about, guys?
Your Honor, can we
Can I
get a
just-
ruling on the motion to reinstate?
Oh, I'm sorry. I already thought I denied that.
Okay, didn't hear it. If I did, I missed it. Never mind. Thanks.
Sorry about that.
And then Judge, on the depots, can those just occur in the next 30 to 45 days?
When's the trial setting?
Well, Judge, we might need to have to get a new trial date now that the county court case that was improperly filed has been consolidated. We've got brand new issues here that very little, if any, discovery has happened.
My only comment on that, Judge, is counsel's entire argument to start this hearing was we've only been conducting discovery on that. So that's not true by his own account. I do not know when trial's set right now, though.
Trial set on August 17th, Judge.
Oh, wow. Okay. Well, then, yeah, these depositions need to take place before August 17th. And then you
Thank you,
guys
Judge.
and then you need to make a decision if you want to move to continue this or not. I'm not saying I'm going to grant it or I'm not going to grant it, but
What are the odds that you think we'd go to trial on August 17th, Judge?
low.
Okay. So I figured.
I mean, what year was this case filed? 2019? I mean, it's not impossible, but low, just because we're so backlogged, but we'll do our best, and we're going to try, for those of you who know me, I'm going to try cases. So I've been wanting to try cases for quite a while now. So, but we are where we are. So let's hope that it goes. So, all right, guys, just get me in order, okay?
Thank you, Judge.
Thank you, Judge.
You guys. Okay, I think we have Jorge Levy Family Limited Partnership versus CKN Land Partners. Anyone here on that case?
Yes, Your Honor. I think all three attorneys are here.
Mr. Whitten, who else is here for that?
Mitchell Madden and Randall Mathis.
Good morning, Your Honor.
Mr. Whitten, where are you? There you are. Okay, let's go on the record on cause number DC 1313456, the Jorge Levy Family Limited Partnership versus CKN Land Partners. Counsel, make your appearances.
Jordan Whitten for the plaintiff, Jorge Levy Family Limited Partnership, directly and derivatively on behalf of nominal plaintiff CKN Land Partners LTD.
Randy Mathis for Jeff Gilbert.
And Your Honor, my name is Mitchell Madden, and I represent your non-party movements, Mr. Graff and his affiliated entity, Remington Crescent LLC.
Okay, let's proceed.
Judge, just to give you a little bit of a background, we have an $816,000 agreed judgment in this case. We've been conducting a host of post-judgment discovery, one of which is this subpoena at issue. We sent out subpoenas to a few people based upon the testimony Jeff Gilbert gave at his deposition. Stan Graff is one of those whom I understand at the time he was working for in 2020 and I believe briefly into 2021. Stan Graff, through his company Remington Crescent, had bought a property at, I believe it's 3959 Crescent. I have the DCAT that I can show you if you need. 3509 Crescent, excuse me. And so evidently he had hired Jeff Gilbert either individually or through his company JGI Partners LLC to do a complete gut and remodel of this very, very nice, expensive property in Preston Hollow. There were questions about how much he was making on this property. Gilbert didn't seem to really know at his deposition. He kind of waffled back and forth on a couple of numbers. And a lot of his testimony was based on I get monthly draws based on how much I finish, and the number really depends. So I'm not really sure. And so the first part of the subpoena is related to, okay, how much is he making off of this? When did he get paid? Where did the money go? Because obviously he owes $816,000, is claiming he doesn't have any money, but is doing a complete remodel of a multi-million-dollar house in Preston Hollow. Something doesn't add up to the plaintiff. On top of that, Judge, if you recall, it was a while ago, probably almost 2 years at this point. We had a situation involving another property in Preston Hollow. It might have actually been University Park, but the entity that they were using was called University Park 4 LLC. And there was a big question about what is this property. The corporate formation documents of that entity had Jeff Gilbert as a manager on salary who had complete control of that entity. And when we attempted to get a writ of execution to seize that property and sell it, there was a big dispute over, was Gilbert actually the owner of that property? So in the same vein, we've also asked for the corporate documents of Remington Crescent, which is not a big company, Judge. I believe, based on testimony, it was created only for the purpose of buying this property and doing this remodel. It was only formed in 2020, I believe. So this is not some, trade secrets, trade dress, anything like that that's invasive for this company. And so we've asked in this subpoena just for Mr. Graff to present the documents relating to that company, just to show if Jeff Gilbert's not an owner or a manager or a member of this LLC, fine, just tell us. If he is, though, we may have a situation like University Park 4, where there's questions of whether this could be subject to an execution order. And so, Judge, I can put the objections on the screen, but rather than produce really much of anything, all I got in response to this subpoena were 7 draw invoices that state numbers and dates. They don't tell me where the money went. They don't tell me anything about, what account they were deposited into, what it was for, why, when these were paid and why. Nothing. They're just blank invoices. And I can, if you'll let me share my screen here, Judge. Let me know when you can see that, Your Honor. So this is the 8 pages that were actually produced. I only got 8 pages in response to the subpoena, and they're all almost identical to this one. They just have different numbers. And this tells me nothing about where this money went. If you look, Judge, it says Graff / Remington Crescent LLC. So it's not even clear as to who is paying this money. We sent the subpoena to Stan Graff individually because he obviously is in control of his companies. But all of these supposed 7 records show that somehow Gilbert was paid over $100,000 for this remodel job, and my client has no idea where it went. We haven't gotten any records from anyone as to a bank account that it went into, but they say on here, bank transfer. So I cannot reasonably conduct post-judgment discovery without more knowledge. And if I can switch over to the objections, Judge, for each of the 6 requests that I sent in the subpoena for Ducis Tecum, I got a paragraph of objections that nothing is relevant, everything is overbroad, everything is private and confidential. And Judge, honestly, I'm willing to work with them. I've said that all along. They've asked for a protective order. I've said, okay, I'll enter a protective order. I'll agree to it, but I need the documents, and I simply have not received what I've asked for. I don't believe the objections have merit, Judge, and so I'm asking that you overrule them and tell them you have to respond to the subpoena.
Response. Who's gonna?
Mitchell Madden, can I share my screen, Your Honor?
Sure.
All right. So if I understand, well, first of all, my clients, Mr. Stanley V. Graff individually and Remington Crescent LLC, are non-parties responding to post-judgment discovery collection efforts. We got this subpoena, and Mr. Whidden tells you, well, he asked, I'll go to the specific request in a moment, but in response to the request, on May the 4th, I wrote him and told him his target defendants have no interest in Remington Crescent LLC and no interest in the property, but we'll send you records to prove all the money that we paid him over the last 5 years. And we did that. And what Mr. Whidden doesn't show you is that we not only responded to the request for production, we gave him a business records affidavit showing where the invoices, the draw requests from his target defendant came from and how much he was paid on each. And it wasn't $100,000, it's a couple of $100,000. We don't have any records of the target defendant's bank accounts. That is a subject for post-judgment discovery. Mr. Whidden could and should take this information and direct at his target defendants. His request for production, again, he wants to gloss over the fact the final response. While we object and we say, look, if you're looking for confidential information, this is my client's entity buying a parcel of land my client owns, a stranger to this litigation. If you want that kind of confidential information, all my client's corporate documents and all my client's contracts, loan documents, title company documents, construction permits, power bills, water bills, and other records. And Judge, when you read these requests, do they mention at all that they are related to or involve his client? He could have done that. He could have just said any of this stuff related to his client, and I could have answered it none. He refused to do that. So I said, read in Ray Croft, read in Ray Patel, show to the court that my client, that your target defendant has any interest in this property or entity other than the money he's been paid for work performed, which we've given y'all, and he's brought forth none. Now, there's not a motion to compel. There's not a response showing you what deposition testimony led him on this foray against my client and my client's property. There's no proof at all that his target defendant has any interest in this property other than receiving the payments for work that we produced. He says again, my letter wasn't good enough. We put in the response. The defendants have no.
Mr. Madden, I get it. Let me hear from the other side again. So is there any evidence that the target defendants have any interest in this company?
Well, Judge, the 7 documents that were produced show that Jeff Gilbert was paid a pretty hefty sum to do work on this property. I have deposition testimony. I didn't file a response. He's correct. I didn't attach it because this is post-judgment discovery. The only thing that has to be discussed here is whether it could be reasonably related to collections efforts that could potentially give rise to collectible property. That Jeff Gilbert and Stan Graff are very, very good friends. Gilbert vacations to a ranch owned by Stan Graff out in rural Texas. You know, this seems like a sweetheart deal to me, Judge. Just by looking at the documentation, the 7 records show, why are you paying your buddy $200,000 to remodel your house? There's got to be some sort of contract there. They didn't produce any contract showing that he's doing this as a contract job, which leads the parties to believe that
let me just say this. Anything related to the payments made by, what is it called? Remington
Crescent LLC.
Any payments made by Remington Crescent LLC to the target defendants, and that would include contracts, any type of work orders, invoices, all of that kind of stuff, anything involving that transaction that is in the possession of Remington Crescent will need to be produced. So the invoices are not enough. I agree. There's supposed to be more. There should be more than just that. But I agree also with Mr. Madden that that doesn't mean you get to do unlimited discovery against what apparently is an innocent third party if there's no evidence that the target defendants have any type of ownership. And so does that resolve all of the issues?
For now, Judge, I think that's pretty much everything. Let me move around 1 second to make sure that that's everything that I was looking for. Judge, one last item is regarding loans. I've asked them to produce any documents showing any loans that were given to Jeff Gilbert or his company in the past 5 years. Again, we've received a host of objections. I would ask that if they're loaning my client money, that could be relevant to how
Loaning
he's
your client money or loaning the target defendant's money?
Well, the third party, I guess the third party non-party loaning the defendant's money.
Okay.
It's request number 5. I've highlighted the response.
All right. So the objection to request number 5 is going to be overruled, and you're going to be ordered to produce any documents that exist, if any.
I've already responded. There's no documents responsive to that request.
I know the objection is still overruled. But if there's any documents, you need to produce them. If there's not, you don't have to.
Thank you, Your Honor.
And so
Anything else,
I guess,
guys?
Judge, just so that I'm clear, numbers 2 and 3 and 4 are the ones about payments. So the objections for those are overruled as well, correct?
No, Judge, I don't think you overruled the objections. I think you.
I can't see them. Can you show them to me so I can see what they say?
I'll show you exhibit number. I'll show you.
Okay, here we go. Well, stop.
Every one of them refer to N. Ray Croft and N. Ray Patel and relatives.
Number 1, the objection is sustained. Number 2, can you show me 2, 3, and 4, please? And I assume Jeffrey Gilbert and JGI Partners are the target defendants, correct?
Correct.
All right. The objection number 2 is overruled, and all documents need to be produced. Number 3. Objections overruled, all documents need to be produced. Number 4. Objections overruled, all documents need to be produced. All right, guys, get me an order on that. E-file it with with the court, email it to my court coordinator. On the order, it needs to say that this was heard on July 12th, 2021, so that I can target it to this hearing, because we're getting so many orders these days. Make sure you email that, share it, make sure you share that with Mr. Madden to make sure the form of the order is correct, and try to get that email to me as soon as possible.
Judge, just for clarity, I think you sustained number 6, but I want to make sure that we
Sustained
have
number
that.
6, correct.
He did.
All right, thank you, Judge. Thank you, Your Honor.
Thank you, guys.
Thank you, Judge.
All right, Mabanta versus Echt. Motion for leave.
Morning, Judge.
We have Ms. LaBeouf, and is Mr. Herring here?
I am, Your Honor. I'm here.
Okay, let's go on the record on cause number DC 18-18484, Mabanta versus Echt. Counsel, make your appearances.
This is Nicole LaBeouf of LaBeouf Law for the plaintiff, Dr. Sheilane Mabanta.
I'm Walt Herring, Your Honor. I'm here for the defendants, Dr. Echt and the LLC. That's the defendant as well.
Let's proceed.
Thank you, Judge. We're here on my motion for leave to amend. This will be the only amendment that the plaintiff has made to her pleading. And I'll tell you briefly what it is that we're seeking to do with this amendment. So the first thing is we add the current name of the LLC. It's changed a couple of times. It's currently Texas Oncology Holding, PLLC. It's not a new entity. It's just another name change. We've pled fraud with greater specificity. We've added 2 claims for negligence and breach of fiduciary duty, which still are in line with the billing and compensation issues that we've alleged and addressed from the very first day. We initially pleaded fraud. Fraud is still there. And then we added negligence and breach of fiduciary duty. And then we've addressed defendant's contention that counsel has raised to me several times. We've said in our original pleading that a third quarter bonus wasn't paid in 2018. There were monies received. There's some contention over the basis for those sums, and we've clarified that there were monies received. The parties can try what that money was for. And we identified further calculation errors, again, just adding specificity to the facts. And we added a request for pre and post judgment interest and the costs of mitigation. Judge, it's necessary to allow plaintiff's amendment in order to prevent manifest injustice. Good cause exists for the reasons you heard last month, and that is the documents that support the plaintiff's claims were entirely in the defendant's possession. They're still being produced as we speak. The initial pleading deadline was October 27 of 2019. That was 7 months after plaintiff sent her first and second request for production. But it was a full year before the plaintiff received any EOBs and discovery. The pleading deadline briefly changed to April 2020. That was still 6 months before we received EOBs. And remember, we came down on a motion to compel. I was told over a period of months, we're almost there, we're getting there. We didn't have everything. And so what the EOBs show us is, what is it that Dr. Mabanta was billing for that actually was billed out, and what monies were received? And that supported the errors in her compensation, which she discovered in 2018. But those errors, Judge, we didn't know that they had done nothing to go back to the payers and renegotiate for at least a cost of living increase. We didn't know until we saw the EOBs that were produced in the fall, and we're having to go through painstakingly because they were paper bounded together, and you have to read to follow the names from 1 month to the next month to the next month. They don't all pertain to the one payor, they don't all pertain to the one provider. So that process took some time. In fact, the parties acknowledging that extended the expert supplemental report deadlines to April and May of this year because of the delays in the production. The depositions were pushed as well, both because neither side wanted to take depositions remotely, and then because and then because we needed to get through the EOBs, and then we, agreed to go to mediation, which went on for quite a bit of time. But defendants can't delay the production, withhold the material facts, push for trial anyway. So remember, the parties came to you last month and said, we've agreed to a December trial. And then you let the defendants choose if they wanted to go forward in August. They said, yes, they wanted to go forward in August, but they can't now say we're harmed by a pleading amendment. My motion for leave was filed in April of this year. And in April of this year, with a December trial date, that was plenty of time, and we were still in the discovery period. In order to determine whether an amendment is prejudicial on its face, Judge, and we've cited you some cases, there are 3 defining characteristics. One is that it asserts a new substantive matter that reshapes the nature of the trial itself, which this does not do. So what we heard from Holly Williams, who was the CFO at her deposition, is, oh, I made errors, but they weren't intentional. That's been their contention. This is sort of a lesser included offense, as it were, a fraud. So either you committed fraud or you made these billing errors out of negligence. So we've added the negligence, but also we've added breach of fiduciary duty for not acting with the payors in the way they should have, which we didn't know. But they did, because they've had the documents, and they're the ones that were responsible for negotiating. The second prong is that reason defining characteristic for which an amendment could be prejudicial on its face is if the opposing party could not have anticipated the new matter in light of the development of the case up to the time the amendment was requested. And Judge, we finally got documents late last fall. We were taking depositions and going into mediation, and the party that's had the documents all along, and whom last month you ordered to produce the reports in a much easier format, which they've had, but we did not, is the defendants. And that third factor would be if the amendment would detrimentally affect the opposing party's presentation of its case. Defendants have argued in their response that this would harm them because they would need to take depositions and discovery on these claims. And I would note that the expert for the plaintiff still has not been deposed, and it wasn't until today that I received requests for her deposition. The breach of fiduciary duty claim rests on what she discovered in the EOBs, which is the failure to renegotiate the contracts, and her expertise regarding when and whether you renegotiate those contracts. So they won't be harmed. The negligence claim is one that their own former CFO is asserting that she may have made mistakes, but that's all they were, is mistakes. So again, Judge, they referred to this as a last minute amendment. The new claims were added in April. Both parties had agreed to trial in December last month. We moved it to August. But you can't come in and say I'm going to be prejudiced when the cure is to have the time that you need to take the discovery you want. Lastly, the defendants complain about spending 2 days of mediation without knowledge of these claims, and yet on April 5th, before either day of mediation, they received our experts report, and on April 30th, they received the new claims, and we then had what was called an expert hot tub a month later, where the experts were brought into Zoom and discussed their opinions. Sorry for the awkward reference, but that's apparently what they're called.
I've heard of expert hot tubs. I thought that's a bizarre way they labeled that. I think it came out of Germany or something. They must have a different idea of what. Anyway,
I think I correctly state that Mr. Herring and I both have been mortified every time we referenced it.
Mr. Herring, what's your response?
Well, Your Honor, not surprisingly, we disagree with much of what Ms. LaBeouf just said. First, I would be remiss if I didn't say the court already denied the plaintiff's request for a continuance 3 weeks ago. That had in it a request to amend the pleading deadline. It was one of the things they wanted to amend. So I believe that the court has really already denied this request, and that alone is enough, I believe, to deny the request. But more importantly, I want to address the substantive issues that Ms. LaBeouf said. First, this is a surprise for us that she filed this in late April, so a couple of months, 3 months before trial, amends her pleading to add negligence and fiduciary duty claims. We have amended the order 4 times. The second amendment allowed her to amend her pleadings in April of 2020. By April of 2020, she had fully discovered these claims. Why? Well, first, the claims of we were not billing correct amounts, that we should have been renegotiating our contracts, et cetera, which is her negligence claim and her breach of fiduciary claim. Certainly, Dr. Mabanta herself, for the 4 years she worked at our facility, knew what her billing rate was and what her code was. She had actual knowledge of what her billing rate was. She didn't need to discover things. But more importantly, we did produce documents early on in this case in July of 2019 that shows the billing rates.
Let me ask you this, because this is kind of how I look at these types of motions, and so I'll just I don't want you guys just shooting in the dark, because I have a definite way of looking at this. What type of discovery would you have done differently if you had known about these claims earlier?
I will get to that, because I do think it's important to note, though, Judge, that the plaintiff's expert report, which was produced 2 months before her pleading deadline, specifically references this event. She says the amounts billed were not renegotiated and remained the same, which had a direct impact on how Dr. Mabanta received from commercial payers. This is demonstrated in the transaction reports we had produced 6 months before, that lists the same allowed amount for CPT codes in years 2013 and 2019. This whole, oh, you didn't produce me the EOBs until, a year later is just a red herring. I can say that because my name's Herring. It's a red herring. It's they knew this enough for their expert in her initial report to bring this up. They didn't amend the pleading the next time we amended the scheduling order. They didn't amend the pleading deadline the next time we entered the scheduling order. And then 3 months before her trial, they amend the pleading. In the meantime, we have been prejudiced because negligence is a whole new, as a judge knows, court knows, negligence is a whole new issue. You got duty, we got different statute of limitations. If she's going to go back to 2013 and claim we should have been doing this in 2013, when she filed her claim in 2018, many of these claims are already time barred. So I'm going to have to assert time defenses. I'm going to have to assert waiver defenses. I'm going to have to redepose the plaintiff on her knowledge of the events at the time, her waiver problems, her statute of limitations problems. I've got to depose her on, I've got to get an expert to address these issues because they haven't been brought forth before. Negligence is a duty. So far, it's just been a breach of contract. Now I got to talk about duty. I got to talk about breach of a duty, where that duty arises. I've got to find out where all that stuff comes from. I can file, I believe actually some of these might be subject to a motion to dismiss for, I don't know if it's a claim. I mean, a Medicaid or Medicare or the payers may have a claim, but how does Dr. Mabanta have a claim? These are all issues that need to be discussed or need to be analyzed. And frankly, we had analyzed this case along as, here are our deadlines. I'm going to move for summary judgment at this time on these claims because we're going to have a trial date in August. I've got to have this to tailor the case for trial, which we've done. We filed the scheduling order. We filed our summary judgment motions a week before the deadline to make sure we tailor the case for trial. And now I'm going to get confronted with 2 or 3 more claims that I'm going to have to address with summary judgment motions to tailor the claims for trial. So I think, and all this costs money. I mean, we are spending a ton of money on a claim that is really not a huge matter, especially for this court. So it seems to me that allowing this amendment at this time is inappropriate.
Prior to this pleading, what were the causes of action? Just breach of contract, or was there anything else?
Breach of contract and some related equitable claims, quantum merit, quantum merit, those type of claims, which we've addressed in our summary judgment motion. But the primary one is breach of contract and fraud. They claim that it was a fraud, and we moved for no evidence summary judgment on fraud. So the big claims are breach of contract and fraud. There's no negligence. There's no breach of fiduciary duty. I didn't have to hire an expert to go out and look at what payer rates are and when people negotiate payer rates, all that kind of stuff.
If this, Mr. Herring, you kind of had me when you said it was just breach of contract, because I can see how different that could be if it's just a breach of contract and then you're expanding it to include fraud claim or other types of claims. But if there was already a fraud claim in place, how's the discovery needed for the fraud claim different than the discovery you need for negligence or breach of fiduciary duty?
Again, to me, it's a duty issue because in a fraud doesn't have a duty claim that you just misrepresented something. That's the common law fraud. A negligence claim is what is the standard of care in this issue for clinics like my clinic? How often do you negotiate these contracts? Can you negotiate these contracts? These are Medicaid and Medicare. 65% of these patients are Medicare. You can't negotiate a Medicare contract. The other 35% of these patients are, I think there's 100 different payers, and you're supposed to go negotiate with 100 different payers, better rates. I have to have my expert go look at those issues. How often do you negotiate that? How often does my clinic size 7 people, as opposed to a huge Baylor healthcare facility or a Presbyterian or those kind of facilities who have much better negotiating power? That's a huge difference between fraud and negligence.
Judge, defendant's expert did address this, as did his CFO, and his expert has taken the position you can't negotiate the contract from a practice's size. These aren't new issues. Nobody's surprised. And we did originally plead breach of contract, fraud, unjust enrichment, quantum merit, promissory estoppel, asked for an accounting. And so these issues we've all discussed and certainly did this spring as the experts went back and forth. But I would like to remind the court, our requests for production were sent in March of 2019. I had to file a motion, we had to be heard. We didn't get an order granting the motion to compel until 15 months later. And it still took, despite the judge's order, another 5 months to get documents. So that initial production that you heard about was documents created by the practice. We didn't have the source documents. And our doctors, all doctors, enter CPT codes, which are billing codes. Here are the services I provided. They don't enter the rate. They don't know anything about the rate. So no, that's not information that Dr. Mabanta had in her possession.
I don't understand why.
I'm going to go. Mr. Herring, I'm going to go ahead and grant the motion for leave. Mr. Herring, you don't have to decide now. If you do want to, I can understand why you might need some additional discovery. If you do want to continue this case, we can discuss that now or in the future. But I will go ahead and grant the motion for leave.
Clearly, Your Honor, it's going to need to be, I'm going to need some additional discovery that I'm going to have to move for continuance on.
When do you want to be reset, or do you want to talk to Ms. LaBeouf and then get back to me on that?
I will talk to Ms. LaBeouf.
Okay.
Thank you.
Grabbing my calendar because I'm old school.
No, he doesn't want to do that now. He wants to talk to you later about it. So have you already submitted an order on this, Ms. LaBeouf?
No, but Linda told me before the hearing, my associate, that she's going to draft one and we'll get that uploaded today.
Go ahead and draft that. Make sure that it includes on the order that this was heard on July 12th, 2021. Make sure that she e-files that, as well as emailing my court coordinator. Make sure she shares that with Mr. Herring before she does, and try to get it to me as soon as you can. Okay?
Thank you, Judge. All right.
Thank you, guys. You guys be safe, okay?
Okay, you too.
Thank you.